we've got a kind of a neat topic and a neat name for it as well. It's AI and litigation, the new frontier.
Yeah, it's kind of like
Star Wars reference.
Star Trek, I think.
Star Trek.
So,
Oh my goodness! I'm gonna get people are gonna comment on that one faux pas for sure. Welcome to another edition of FH&P Lawyers Law Talk. I'm Clay Williams. I'm a partner here at FH&P, and you can find us on Spotify, Apple Podcasts, YouTube, and now this is new for us on Rogers TV as well. So today we have David Horvath. Welcome, David.
Thank you. Happy to be here.
So AI, boy, you can't turn on the radio, can't look at a podcast without somebody talking about AI. So I guess it's our turn today.
Exactly.
But we've got a bit of a focus on it. It's AI and litigation. So what are you going to talk about, and what brought that all up?
Well, AI is right now the wild, wild west. Everybody has an AI. Everyone's using it. And in my practice, what happens is clients come in. Usually there's two situations where they use AI. They come in and, with a ChatGPT printout saying, this is what I think my case is about. Tell me if I'm wrong or right. Or they file something with the court and they use ChatGPT or any of the AI services, and there may be some issues with that from the court's perspective. So they come in for advice about that.
Actually, that just happened to me. We did I think it was a shareholders agreement, and the client ran it through ChatGPT, and ChatGPT gave their comments about it, which concerns me a bit because that, of course, goes out into the World Wide Web. But yeah, that happens, and sometimes ChatGPT has good ideas. Actually,
it does, and I find sometimes it does have good ideas, but it has to be reviewed by a lawyer. So you'll get those comments from ChatGPT saying, "Look, I'm not a lawyer. Go take this to a lawyer," which is helpful. And I've had clients do the same thing. I've had clients put my work through ChatGPT when I've sent it to them. After things have been filed, and usually it's A-OK, so that's great, but it helps them also understand a lot of the legal jargon that we use at the end of the day.
Yeah, I completely agree with you that it's so easy to put your legal problem into ChatGPT and get something out, but boy, I still think you need that background to understand what is being told, and sometimes it's not true.
And sometimes it hallucinates, and there are a couple of cases where lawyers have actually used AI and provided that argument to the court, and that resulted in sometimes sanctions, sometimes a stern talking to, and sometimes a case being dismissed. Because what happens with AI, especially open source AI, is it provides fake case law sometimes, fake legislation that if you don't check it, and you rely on it, the court is going to check it and discover you using fake cases or fake law. And that is not going to go well for your lawsuit at the end of the day.
Yeah, that's happened to lawyers too.
Yes.
Not just lay litigants. But I mean, I guess one of the things that we are seeing in the courts a lot more of is lay litigants, and people bringing their own claims and, relying on ChatGPT for their legal arguments, for the case law, and boy, that get you in trouble.
It can, and if you do that, first of all, call FH&P and we'll review what you have and probably suggest some changes. But if you do proceed with it, what can happen is the court may dismiss your case at the end of the day. So if you sue someone in BC, whether it's provincial court or Supreme Court, you have to file what's called a notice of civil claim or a notice of claim. And that document identifies what your case is, what your lawsuit is. And in that document, you have to be very specific about what your claim is. You have to articulate what's called a cause of action. Cause of action is a term of art that basically indicates you have a right to sue someone and what that right is. So an example is negligence or someone breached a contract, but it's very specific and has a specific legal test. Everything in that document has to relate back to that legal test. So when you put things through ChatGPT, that might not happen. Most of the time it doesn't. And there might be superfluous things in there that don't matter at the end of the day.
Yeah, and I think ChatGPT can spit something out But if you're not understanding when it's alleging fraud and what the repercussions for that might be or things like that, then that can get you into trouble.
Oh, it does, and usually these AI spit out something that is favorable to you. So it not only gives you some jargon and some explanation, but it also tries to convince you that your case is right. But when you come to us, when you come to me, and we sit in a room, I always say to folks that my job is to tell you the good, the bad, and the ugly. So I'm not your cheerleader. At the end of the day, we tell you if your case is good, bad, or somewhere in between. These AI usually just try and garner or cater to you, So it's really important to have your materials reviewed by a lawyer. And if you don't, you might wind up in a situation like a couple of cases I've run where the materials get struck off the record. And dismissed at the end of the day because you weren't clear in your notice of civil claim about what your case is about.
Actually, that's the reason that you wanted to discuss this, is you've actually got some experience with that, with clients that have had to deal with lay litigants who have brought basically ChatGPT cases, and you were successful in having those struck.
That's correct. So in that specific case, it's unclear whether there was AI used, but in that case, it's a situation where lay litigants filed a notice of civil claim alleging various things. One is negligence on the basis of some bylaw infractions. And it's taken, about 5 years now to go before the court multiple times to try and dismiss their claim and strike it, and that's the term used, striking the claim. And we were finally successful recently to strike that negligence claim, for instance.
I just want to talk a little bit about the reasons people are in the Supreme Court on their own. And, I think a lot of it is cost. And so, when we say, well, come to a lawyer, that's not available to everybody, I guess. And so there is more of this ChatGPT being used by lay litigants, people showing up on their own. But, we should talk a little bit about ad hoc legal services and unbundled legal services. And so, in the old days, the traditional model was that a client would come in and we would take their case on and we would run that case through to trial or settlement. But that doesn't have to be the case nowadays. And we're doing more and more of this.
Oh, and I'm doing a lot of it now with AI because you can save on those costs. So when clients bring in their own AI material, I can review it and it's less time we're spending on the file. But if it's an unbundled service or what we call a limited retainer service, what happens is it's kind of a pay-as-you-go situation where we agreed that, we maybe draft the notice of civil claim or do certain things, but not appear in court. And we're very specific about the boundaries of that. And it's usually that they go to court, we kind of advise in the background, and that way you're saving a lot of money versus if you're sending a lawyer in to do everything. And you're also getting that legal advice at the end of the day, which is excellent for your pocketbook. Yeah. But then you're not in Supreme Court with AI information that may or may not be correct.
Yeah, how to articulate your claim using legal causes of action, I think, is so important because people do not have the background that we've been trained to do. So, that's important. And like we say, we in some situations, especially people that can afford it, people that are very confident people, we can provide some assistance in the background without doing everything. So, and I think you're seeing it too, aren't you? Like people are taking advantage of that.
They definitely are with limited retainers and AI. They are definitely taking advantage of it, and they're doing a good job. And I think that's one of the benefits of AI in our society right now. Some of the risks here, like I said, are AI might hallucinate. You have to have some understanding of the law to understand what it spits out to you and how you articulate that to a court. So in an unbundled service or limited retainer, we might have a client who has a fraud claim or a negligence claim, and we advise them about it, but they may not be able to articulate that to a judge, especially if it's a very complex situation. So the more complex the case, the less useful AI can be. However, the caveat to that is, if you're dealing with a lawyer like one of us, if it's a complex matter, you can run what we're telling you through AI. And I've had clients do this, and they come back and say, okay, now I understand what you're telling me. Yes, there's issues with privilege there, but at the end of the day, AI allows clients and the public to understand what we're saying and what the court wants to hear from them.
Interesting. So you're kind of an AI fan. You're on the side of using AI if you're a client, then, eh?
I am. I advocate for it at the end of the day because it helps clients, and that's what we're here to do: is help people, help the community to engage with their legal disputes in a cost-effective manner. So AI does help, but it's not the be-all, end-all, and lawyers are required at the end of the day because of all of these issues. The legal jargon involved has to be articulated in a certain way. And if you don't, the risks are that your case may be dismissed, like that case I told you about, where self-represented litigants walked into court with, I think a 55-page notice of civil claim, which you and I know that is really long.
It's prolix. I love that word.
Yes, their pleading was called prolix by the court multiple times, and they tried to fix it, and they weren't successful at fixing it. So the court won't dismiss your claim if you make a mistake once. They try and assist you, but if you keep doing it, then what ends up happening is what happened in this case, and that negligence claim that I mentioned was entirely dismissed because they weren't able to fix it, because it was not correct on the law.
They were given an opportunity, and enough is enough, I guess, at the end of the day.
Exactly. And that's why my practice, when I see self-represented litigants on the other side, I usually send them a letter and say, these are the problems with your case. And that's an opportunity for them to fix it. And the court wants to see that. So when we walk into an application to try and dismiss that case, the court looks at the letter. They look at, well, have you been given an opportunity? Is this the first time you're hearing this? If it's not, that goes against you. So you do have the chance to fix it. And if you're on the other side, it's very important that you do try to do that, whether it's you're using AI or lawyer or not.
Okay, I see you've got in your prep notes here, what are some of the reasons the court may strike a claim? Anything else that you haven't talked about?
Well, the court may strike a claim where it's an abusive process, for instance, if you're just going after your neighbor or your business partner just to be vindictive and there's no real substance to your claim. If your claim is vexatious and frivolous, so there's a specific analysis for that. But if it's really not articulated on the law, really. The other one is where there is no basis in law. So that negligence claim I mentioned, that was struck because of that, as well as an abusive process. So in those types of situations, what is important is what you've written on that piece of paper, on that notice of civil claim. So the court in that application that I mentioned is going to look at only that. There's limited amount of ability to bring in evidence about proving your case. It's not about proving your case. It's about articulating your case to the other side. If you haven't been able to do that in that one document, because you use ChatGPT or you wrote it yourself and it's not what it needs to be, the court can dismiss it for that reason, albeit there is an analysis where they try and give you chances. So one of the parts of that entire analysis is, well, is there an opportunity to fix this document? And if the answer is yes, the court says that the litigant should not be driven from a driver's seat of the litigation, and they'll give you that opportunity. But there are many, many cases where they have given self-represented litigants multiple chances to fix their notices of civil claim, and they fail to do that, and eventually someone like me will be on the other side, and the court will agree to dismiss the case.
And I think a lot of people that go to court themselves, they don't realize the time pressures that are involved. And, our judges have just an onslaught of litigation to deal with. And so when you see a 50-page notice of claim, that's not going to help you, You've got to be able to say, this is what the case is, and these are the causes of action, and this is what I want. And you've got to be able to do it in a concise way that a judge is going to understand. And so going in just thinking, well, I'm going to put everything in there and something's going to stick, that doesn't help sometimes.
But that's natural for anybody out there. That's natural. You want to tell your story. You want to say this is what happened. This is the wrong. But the law doesn't work that way. You have to articulate in a very specific manner and not 50 pages, very succinctly, so the other side understands the case. That's what the Supreme Court civil rules provide for at the end of the day. And in that case that I mentioned and referenced it, the judge quoted the other counsel about the fact that it shouldn't take hours to review a notice of civil claim to understand the case. In that case, the notice of civil claim was called prolix in almost every iteration because of that. Because when I even first read it, I didn't know exactly what they were trying to articulate, because our jobs is not to try and make the claim for the other side, but is to try and understand that notice of civil claim and what the lawsuit is about. And if I can't do that with 7 years of training, then that's a big problem for the court and the judge who's sitting up there, who can't understand what you're trying to tell them. And they want to listen, they want to understand, but it has to be done in a certain way.
And at a certain time, right?
Yes.
You know, there's the notice of claim, and you know you'll get your chance, but you know, in that document isn't the time. And that's a danger too. You know, people are just putting too much information, too many facts into it. You know, so
Exactly, and you see that all the time with self-represented people, and they want to tell, like I said, their entire story, and it might not be important, for instance, that you went to the store that day, but it might be important that you were injured when you fell, for instance, or someone breached a contract because of X, Z, and Y conduct, but it doesn't matter what they were wearing that day, for instance. So being very, very clear and very efficient in the word usage is very important.
So you said something that I found was interesting, and that's that you know you're a fan of artificial intelligence, and so do you actually tell your clients to say, look, you know, if you don't understand anything, then you know, explore the concepts with AI and you know, do that on your own time?
You know, I haven't done that specifically, but I think it is a good idea now that you bring it up, because there's an issue there of privilege. So we have solicitor-client privilege with our clients when they come in, so we can't relate what they tell us to anyone else. But if they choose to, I would recommend they look up the actual concepts. So not putting what I send clients into ChatGPT to really understand what is being said, but rather to, you know, put in the concepts, put in what negligence is legally. What do you think that is, ChatGPT? What is a breach of contract? You know, putting in fake names always helps. So I don't recommend necessarily putting in your drafted notice of civil claim that I send you, but
Well, because it goes on to the web.
Exactly.
And that is a concern.
That's a big concern, because open source AI, as you know, takes information from everywhere. So feeding something into ChatGPT, like a legal document that is privileged, could open solicitor-client privilege up.
Are lawyers getting replaced by AI? And you know, I don't see it. I think of this. I think what you said makes a lot of sense to me. You know, like when I go to my doctor, I mean, I think knowledge is power. I want to know what is being prescribed and why. And, you know, it used to be Google and, you know, but this AI is pretty neat stuff. So, you know, I think that we've done that with doctors. Why not do it with lawyers?
No, exactly. And there's a lot of complex concepts that we deal with every day, and AI gives people power to understand those in a way that they haven't been able to in the last 100 years or so, because it's right there, it's in plain language that they can understand once they put it into AI. So I don't think we're going to be replaced by AI anytime soon, unless you reference the Terminator movies. But aside from that, we're still going to go to court. We're still going to advise people about, their disputes, but it's going to be easier to communicate. And that's what I think AI is great at, is allowing people to communicate with their lawyers, communicate with the court, communicate with the other side. What is the problem here? What are we having a dispute over? And how can we resolve it? And that really leads to less court time, which is a problem, as you know, nowadays. Not enough court time trying to get before a judge is a problem. So all of that assists with the access to justice. So yes, I'm a great believer in AI, but I I don't think they're going to replace us unless there's a robot that can walk into court and argue everything that we argue. I think our jobs are safe for now.
Well, what was Terminator?
Skynet, yeah.
Skynet?
Yeah.
Until Skynet becomes sentient. Was that the start of it? And
that was the start of it, yeah.
So, but for now, no, I'm with you. I think it's a great tool. I don't see it. I think asking it to create an agreement for you, asking it to create a series of questions for you without really knowing why is dangerous. So take advantage of it. Come in, talk to David, and he'll help you out. So thanks for tuning in, and thank you, David, for doing a great job. David is one of our senior litigators here at FH&P. If you've got any issues you can't resolve, and you have to litigate, David's your guy. Tune in next time. You can hear us on Spotify, Apple Podcasts, YouTube, and now Rogers TV. If you like what you hear, please do subscribe or follow, and or give us a thumbs up. Please leave your comments down below, and we'll try and answer them as we get them. Thank you. Till next time.
Perhaps no comments about Star Trek or Star Wars.
No, that was a misstatement. So, okay, till next time.